Good morning and welcome to another edition of the Daily Fix. I am your usual host and presenter, Advocate Tulohoyani. So the state in the MEYIWA case has wrapped up its case. There are two things that I want to bring to your attention this morning, which are very important. You remember that immediately after the state announced that it has wrapped up its case, Advocate Nisi rose up to say he just wants to get clarity on the issue whether now, in view of the fact that certain witnesses who appeared on the list of witnesses of the state were now available to the defense. And it was about at that time that Judge Balu immediately stood up and told the court that the law is very clear on this. Those witnesses are now available to the defense. The most crucial thing about the availability of this witness is one person, and one person only, and that person is Kelly Khumalo. You see, Kelly Khumalo has been fingered or was identified at the beginning of this trial as a potential witness because a cell phone had been robbed from her. So if things had been done properly, or the expectation was that Kelly Khumalo ought to have been called to that witness stand to come and testify to the robbery charge. She was not called. Interestingly too, Kelly Khumalo has been identified as the mastermind, but as the state wrapped up its case, there is still no indication whether Kelly Khumalo will ever be arrested. So the point that I'm making here is Kelly Khumalo is now available to the defense. The defense can simply subpoena her, and question her along the lines of that mastermind theory. That is how Kelly Khumalo must be brought to that court. And of course, common sense tells us that Kelly Khumalo, if she turns up in that court, she will never own up to being the mastermind. And that will deal a serious blow to the prosecution case because, as the prosecution stands now, one of the disclosures by Gininda was that Kelly was the mastermind. So it will throw, the state case into some kind of mini chaos. But anyway, Kelly Khumalo has not testified. So the defense can do something about Kelly Khumalo, get her to the stand, get her to deny that version put forward by Gininda. You see, because that version implicates the accused, much as it leaves her out, or much as she has been left outside and has not been arrested. But it implicates the accused in the commission of this crime. Because you see, Kelly Khumalo is the mastermind, but she's left out. But the foot soldiers are sitting in that courtroom facing a murder charge. So it would be very important and very crucial to get rid of that mastermind evidence by way of calling or bringing Kelly Khumalo to court. And the natural expectation is she will deny that she was ever the mastermind behind the killing of Senzo MEYIWA. Now, the second thing that I want to look at is the Section 174 application that the defense intends to make. The Section 174 application goes this way. It is provided for in the Criminal Procedure Act 51 of 1977, which governs the conduct of criminal trials in South Africa. Under 174, if at the close of the Crown case, like the state has just closed this case, if at the close of the state case, rather not the Crown, if at the close of the case, of the state case, right, the defense is of the view that, there is no prima facie evidence, or there is no, let me call it prima facie evidence at this stage, right? There is no, evidence pointing towards the guilt of the accused. they are perfectly entitled to make a Section 174 application for the discharge of the accused. In other words, the upshot of that application is that, there is no evidence which has been led up until the closure of the state case which a reasonable court can rely upon to convict the accused. So they will be making up that application, because the other leg of that application is, short of the accused coming before court to come and implicate themselves, the evidence that has been led by the prosecution, no court can rely on it for a conviction. So that is the route that the advocate minister and his colleagues want to take. Now, 174, that application will have to look into all aspects of the evidence led by the prosecution. In other words, on the strength of the prosecution case, would a reasonable court, looking at the evidence that the prosecution has led up until that stage when it closes this case, would a reasonable court be in a position to convict based on that evidence alone, without the accused persons themselves taking the witness box and possibly, convicting themselves out of their own mouths? In other words, does that prosecution evidence on its own, right, looked at objectively, would a reasonable court, looking at that evidence objectively, would a reasonable court, under the circumstances, convict? So it will be very interesting how that application proceeds on the 7th of August, because the case has been postponed to the 7th of August, because it is now an exercise of going through the evidence piece by piece to give an analysis of that evidence and to break it down. So in the next episode, which will be coming on later during the day, I will get into now the nitty-gritty of this evidence to say to ourselves, is a Section 174 application, sustainable? Will it be possible for the defense to mount that Section 174 application successfully? What sort of, lack of evidence, because they've got to show lack of evidence here. They're not supposed to bring any evidence. You see, because the accused are under no obligation to prove their innocence. They have just got to poke holes into the prosecution evidence to say no reasonable court can, under the circumstances, convict. So in a later edition of the Daily Fix today, I'll be going into the nitty-gritty of those pieces of evidence to further, throw more light into what the implications of that application that will be coming on the 7th of August are. Having said that, let me thank you for watching this video. Let me thank you for all the likes and shares that I'm seeing. Like I'm always saying these days, I'm on the way to the, that magical 10,000 subscriber mark. Make it happen. You can make it happen. It is just a click away. Thank you very much.